Welcome friends. I, Dr. Anup Kumar, Assistant Professor, Faculty of Law, Banaras Hindu University, welcome you all at Swayam platform. Friends, here we are discussing about a course titled as Hindu Personal Law, including Law of Marriage and Succession. Today, I am going to start the third lecture. The title of this lecture is Origin of Hindu Law. Before starting anything, I want to recall you about the last lecture. In the last lecture, we tried to understand the technical terminology related with Hindu law. Why we discussed technical terminology in the last class? Before starting a subject, we are bound to know the subject in the true spirit, and therefore without understanding the key concept in a proper context, we can't understand the subject. Therefore, we discuss the idea of dharma. We also explain the idea of religion and distinction between the religion as well as the dharma. We focus on Shruti, we also understand the Smriti, custom, commentary and digest. We also discuss on the Sapinja relationship, privated degree. We also understand the idea of Stridhan, Karta, everything. By knowing the meaning of technical terminology, now we are empowered enough to explore the idea of Hindu law in proper true concept. Therefore, now I want to discuss the origin of Hindu law. First, I want to explain you the learning objective of this class, to understand the basis of Hindu law, and the second, to explore the idea related with the origin of Hindu law. We have a different concept. How we can understand the concept and how we can explore the ideas related with origin. Friends, the fundamental question is why we should focus on the idea of origin. Friends, every law have a root, especially family law bound to have a root, because family law is a living law and it gradually developed and evolved in a given legal system in a specific society. Therefore, knowing the root is very crucial to understand the law in proper context. Therefore, I specifically introduce the ideas and perspective about the origin of Hindu law. The different scholars have a different perspective and viewpoint about the origin of Hindu law. Therefore, we are now going to explore the idea related with the origin of Hindu law. Now, the first fundamental point of the origin of Hindu law can't be explained without explaining the idea of Ved, because Ved is fundamental for this Sanatan tradition. The Sanatan traditions evolved many things. Personal law also rooted in Sanatan tradition. Therefore, these traditions cannot be explained without quoting, referring, or without taking the help from the Vedas. Therefore, Gautam says that the Vedas are the source of the sacred law and the tradition and practice of those who know the Vedas. Means Gautam highlighted the role and importance of Veda in order to create a background of the law. Veda is everything, friends. Now the fundamental point is raised by the scholar through Mimamsa Sutra, where they tell us that Ved is very fundamental, and he laid down three propositions. The propositions are: first, what is good for the man can be learned from the Vedas. Everything which is good for human being must be learned from the Vedic perspective. Therefore, Veda is crucial. The second proposition of Jomini is it can be learned from the Veda only, because Veda is eternal, fundamental, essential. Therefore, if you really want to study something with proper context, with the practical knowledge and standard, we are bound to focus on the Veda. And the third is, friends, whatever the Veda says must be true. Means Jaimini identify three rules propositions in order to the Vedas. You may learn everything from the Vedas, and you can learn from the Vedas, only from the Vedas, and what Vedas suggested is true. Now, the important point is, although the Vedas are considered the foundational for the Hindu law, they do not explicitly lay down the detailed legal rule and directives. We may explain this line differently, because in one hand scholars suggested that Veda contains principles, therefore you cannot trace the legal principles from Vedas. But in other hand, scholars concluded that we still not investigated Vedas from the perspective of law, because we are thinking that law is external and what is prescribed by legislature or parliament is fundamental for the law. Therefore, our generations never investigate Vedas from the perspective of law. Therefore, we have very little knowledge what is the exact law mentioned in Vedas. But the principles are very crucial, and therefore Veda is considered the fundamental. Instead, Veda includes indirect or occasional references to the topic that relate to the law. The concept such as dharma, duty or rightness, which later become central of the jurisprudence of the Hindu law, are rooted in the Vedas. Therefore, we can't think about the Bharatiya jurisprudence or about the Hindu law without quoting, without referring, or without knowing the Vedas. Therefore, if we are going to discuss something about the social practice, social traditions, we are not in positions to ignore Veda to discuss the fundamental aspects which are governing the people residing in Indian society. Therefore, the idea of origin of Hindu law cannot be started without quoting, referring and understanding the Vedas. In this regards, Veda is the foundational for the purpose of origin of Hindu law. Now, I want to focus on the perspectives on the origin of law. Perspective means approaches. We have a two different and distinct approach about the origin of Hindu law. The one approach is developed by the Bharatiya jurist, another is developed by the Western jurist. They have a contradictory opinion and they have their contradictory stories about the origin of Hindu law. One says that Hindu law has divine origin, and another hand others tell us that Hindu law is based on a custom time immemorial. So let us explain the two conflicting perspectives in order to understand Hindu law in totality and in proper context. The point is the approach of Bharatiya jurist on the origin of Hindu law. This is the fundamental how Indian people, Bharatiya people exploring, understanding, realizing about the law when they are thinking about the law. Friends, Hindu consider Hindu law to be divine origin and derived from Vedas, which are eternal in nature. Hindu law have divine origin. This terminology have a greater significance. Why it is greater significance? Because different scriptures related with Hindu law declared that the law is the king of kings and it enables the weak to prevail over the strong. Hindu law is a king of kings which enables peoples. They are weak. They may have a right due to the law. This is the fundamental point. Therefore, Hindu law was independent of the state and it was binding on sovereign and subject both. Why, friends? When we are thinking that Hindu law is not prescribed, originated or derived from a state or from a king, means Hindu law derived from Vedas. Vedas are Apaurusheya, means something which is prescribed by the legal scholar and other people. So therefore, it is prevailed over the king as well as the subject of the sovereign authority. Therefore, in Bharatiya tradition, we think that Hindu law considered as the highest monarch, means nothing is the above the law. Law is supreme. Everyone bound with law. Therefore, the tradition focused and concluded that Hindu law is the law of king, and this line have a greater impact on the legal tradition. Why? Because in the Western jurisprudence, when they consider that law is a command of sovereign, therefore ultimately sovereign become more stronger than law. Therefore they introduce the idea of sovereign immunity to declare that sovereigns are immune from the law. But in Indian traditions, we placed sovereign as well as common people at equal status for the purpose of law. Now we are thinking about the rule of law. Therefore, this point is very crucial that in Indian traditions, we are thinking that no one is superior than law. Law is ultimate monarch, ultimately superior. This is a great jurisprudential significance, and therefore friends, in Indian tradition, arbitrariness is never accepted, friends. The king in Indian traditions also bound with law. No one can say that we are above the law, because we are aware about the story of adandyosmi, adandyosmi, no adandyosmi, dharmadandyosmi, dharmadandyosmi. You are not above the dharma, you are within the dharma. This is the greater significance of the Bharati perspective when we are explaining the idea of origin of Hindu law from Indian perspective. In India, we consider that Smritis as a second stage in the development of Hindu law. Why it's second stage? Because they evolve and develop the law on the basis of experience and practice. If we are think about the Indian context, we are bound to think that Hindu law originated and rooted in Vedas, evolved in Smritis, and the discussion on dharma and law continued thereafter with commentaries and digest. This is the entire traditions which is beautifully coined by the Mullah. The law originated and rooted in Vedas, evolved in Smritis, and discussion continued, and this continued discussions led down the various commentary and digest. Their authors, means the authors of the commentary and digest writers, make the subject simple and easy to understand. They have given a definite meaning to the doubtful and difficult portion of the Dharmasastra and try to resolve their mutual conflict. The commentator bridges the gap by wisely interpreting the original text in such a way as to bring them in the harmony with prevailing condition of society. They also included custom and uses prevailing at that time. This narration explain us about the development and origin of Hindu law. The law developed from Vedas, and now we have a law. The continuity is not breaked. We change the form of law, but spirit is still continue. For example, of marriage, we considered marriage as a sacrament in Ved, and now we are regulated by the Hindu Marriage Act, and section 7 of Hindu Marriage Act concluded that marriage is a sacramental union. In Dalirani case, Supreme Court further in the year 2024 further concluded that Hindu marriage is not a contractual union, is a sacramental union. This is a legacy which continued till today. This is a perspective which is developed by the Indian scholar about the origin of Hindu law. This is the point and perspective which should be explored for the proper understanding of the Hindu law. Now the second point is the Western perspective on the origin of Hindu law. How the Western scholars think about the Hindu law. The Western jurists do not accept the idea that Hindu law has a divine origin and argued that it is based on immemorial custom that exist prior to the Vedic origin of law. This is the idea. They focus on the custom which exists from time immemorial, and they think that at primary level Hindus have no text. They developed entire law on the basis of the custom, and therefore custom is in the root of entire development of law. This is their narrations, and they narrated their stories differently. How they narrated the story? It is very interesting. They focused on a wrong notion and concluded that where the Aryan came to India, they found some customs and uses were same and some were different. Means entire Western perspective about the origin of Hindu law is totally dependent on a concept Aryan came in India, but now this is rejected idea. But they argued that when Aryan came in India, what they found? They found that some traditions are as equal to them, but some are different. Subsequently, the Western scholars argued that Brahmanism plays some role to development of the Hindu law. Brahmans altered the traditional custom by embodying the religious element into the legal doctrine by introducing the pious purposes into purely legal and secular act. This point to be noted and explored: secular act and religious act. For example, succession, maintenance are purely secular act, but what they narrated the story that people connected and mixed secular act with religious act. Therefore, in Indian tradition, it is a mixture of everything, and therefore they focused on that. Due to provide prominence to the Brahminical law, people aid restrictions, introduce the pious obligations, and therefore entire secular law become religious law. So this is the Western notion. When they started focusing on custom time immemorial, and by the introducing of the contemporary Hindu law, and where the Aryan play very pivotal and crucial role. Now the question is, friends, how we can criticize and how we can understand the proper law of the idea. Therefore, there is a need to appraisal both the perspective on the origin of Hindu law. According to the main, both the perspectives are incorrect, since the work of the original text along with the translated commentary and digest, it has become clear that Smriti were partially derived from prevailing or earlier custom and partially from the law established by Hindu jurists and the ruling authorities of the countries. Means so long as now we are aware about that, we had a tradition of fundamental text. We have a long history of textual tradition. So why you are not focusing that Hindu law is a law of Smriti? Because scholars says is develop the Hindu law. This is the crucial for the purpose of the development of Hindu law. The one of the narrative which was originated and developed and argued by the scholar is Hindu law is developed due to the armchair methods. Sages have no connection with society, scholars have no connection with society, but they develop the law from different perspective. No, this is not based on armchair methods. This is based on the practical experience and day-to-day working of the Indian courts and legal system. Therefore, commentators and Smriti writers, digest writers introduce the exceptions, they introduce the law, and they evolve the law on the basis of the practical experience. Therefore, you can't say that the entire Hindu law originated from the methodology of armchair. It is practical, and it is the outcome of the experienced, what experienced by our forefather or the Indian scholar. Therefore, the point to be noted that the scholars are going that commentator and digest writers were equally play very pivotal role in the development of the Hindu law. He further noted that while presenting their commentaries, they elaborated on the rules in greater detail, distinguish between the Smriti rules that remains applicable and those that had become outdated. In doing so, they also incorporated new uses that have emerged over the time. So, this is the perspective by that we are able to understand the fundamental development of law. Now, how we can conclude the entire discussion related with two different perspectives about the origin of Hindu law. The first is, Hindu law cannot strictly to be said to have been promulgated by any sovereign within the meaning of Augustinian definition. I already told you that Augustine have a narrative, law is a command of sovereign. But you can't explain the Hindu law from the lens of Augustinian jurisprudential model. This is not strictly laid down by the sovereign. It is developed by the experienced scholar on the basis of their experience. They are neutral, they are in neutral state. They understand the problem of society and gradually contributed in the development of law. Therefore, the source of origin of Hindu law not rooted on a sovereign authority, but it is derived from the legal scholars who actually involved in a day-to-day practice of law. But Hindu law is a body of principles or rule recognized and allowed by sovereign to govern the subject. So this is the fundamentals. Sovereign not declared the law, but sovereign recognized the law in day-to-day activity. This is the great example of separation of power, where executive is not allowed to develop the law. Executive is only facilitating the application and enforcement of the law. And after the independence, the parliament enacted the various laws which regulating the personal affairs of Hindu, keeping in the mind of some traditional aspects of Hindu law. Why I am compelled to conclude this? Because all the act which is now prevailing on Hindus are the codified legislation. Friends, we are very clear about the codification and legislation. Codification means what was prevalent in society, compiled by the legal scholars and introduced for the betterment of the society. The codifying law means what applied in Indian tradition was recognized, traced, identified, classified, and then codified by the sovereign authority. So it is codifying legislations. So these are some fundamental conclusion about the origin of Hindu law, which we can explain about that. Now, the important aspects is section 4 of Hindu Marriage Act, which provides that any text, rule or interpretation of Hindu law or any custom or uses as the part of that law in force immediately before the commencement of this act shall cease to have effect in respect to any matter for which the provision is made in this act. After the legislation, the law which already in practice have no effect for which the provision is made under this act. But friends, recall that for which the provision is not made under this act, we are able to apply those Hindu law in contemporary India. So section 4 in one hand is stating the overriding effect, simultaneously it's open the scope of area where we can apply the traditional Hindu law in contemporary society, for which the provision is not made is a crucial terminology mentioned in section 4 subclass A. Therefore, we should focus on that point. Now, please think about certain points. Whether the development of Hindu law is based on practical experience of the legal scholars on the basis of day-to-day activity of the administration of justice. Because scholars raise a question that this is the based on the armchair method. But my fundamental question is, Hindu law is not based on armchair methods because it gradually developed. Certain core principles exist in the form of Rit, further it developed from the form of Dharma, further it evolved in the form of the Shruti and Smriti, and further it evolved in the form of contemporary context. Therefore, we can't say that this is a law which is based on armchair methods. So we should think over that, whether it is an outcome of armchair methods or it is an outcome of the tested model. We should think when we are thinking about the origin of law. So now I am summarizing today's lecture. What do you mean by origin of Hindu law? Means explain the story related with the evolution of Hindu law. We have two contradictory approach. One approach is Bharati perspective, another approach is Western perspective. Bharati perspective concluded that Hindu law originated from Vedas. Vedas are apaurush, therefore Hindu law have a divine origin. Due to divine origin, Hindu law applied on sovereign as well as subject of sovereign. Therefore, law is supreme. Therefore, sovereign as well as subjects is bound to apply the law and bound to respect the law. In Indian tradition, king is not a creator of law, but king is accepted as an administrator of law. Means law is supreme, you are not supreme. Despite of this conclusion, Western authors concluded that Hindu law developed from the custom time immemorial, and Aryan came, Aryan modified, and therefore we have a law. But this idea is not correct, because now we have a translated Smritis. We also have a detailed list which is explained by the P.V. Kane in the great book of history of Dharma Shastra. Therefore, we are bound to conclude that this approach of custom and the origin of Hindu law through the custom is not appropriate. Thank you for your attention.